Thank you, everyone, and welcome. My name is Erin Fagnelli. I am an underwriting attorney and manager here at Chicago Title Insurance Company in Pittsburgh, PA. I've been in the title industry for more than 20 years, and we bring with us today my fellow co-presenter, Frank Koser Jr.
Good afternoon, everyone. I'm Frank Koser. I'm an attorney at Meyer, Encumbrances and Scott in Pittsburgh. I've been drafting deeds with unfettered enthusiasm for 22 years and look forward to hopefully telling you some things you don't know already about deed drafting today. So obviously at any point during this seminar, if you have any questions, please feel free to let us know. We're glad to answer questions. Obviously, we hope that you find this informative, and hopefully you'll find the next hour to not have been a waste of your time. So let us get going now. This seminar is entitled 9 Things Attorneys Need to Know About Deed Drafting. And the first thing we're going to touch on, the first thing you need to know when you draft a deed is, how is title going to be held? Is it going to be held as a tenancy in common, as a joint tenancy with right of survivorship, or as a tenancy by the entireties? Now, I'm sure all of you remember from first-year property law, this is the 3 different ways in which title can be held in Pennsylvania. There is no other way title can be held except a life estate, but we'll touch on that later. So a tenancy in common requires only unity of possession. Each tenant owns a fractional share of the whole interest in the property and may dispose of that share at will. There's no right of survivorship. Upon the death of a co-tenant, his or her share passes to his or her estate, and an individual's co-tenant share can be freely encumbered. So essentially, in a tenancy in common, each person owns their own fractional interest of a property, and it can be an unequal interest. So using an example, let's say that Erin and I buy a vacation home for $300,000, and she puts up $200,000 and I put up $100,000. We can draft a deed that we're tenants in common, with Erin owning a 66.67% interest and me owning a 33.33% interest. Similarly, I can then mortgage my interest in the property without her consent. I can sell my interest in the property without her consent. And similarly, in the event that there's a judgment entered against me in any civil action or tax lien or anything, anything of that nature, my creditors can execute against my interest in the property, not affecting hers.
And tenancy in common is the most common type of way that you can hold title. If there's no designation in the deed, for example, title is conveyed to Frank Koser and Erin Fagnelli with no designation, we presume that it's tenancy in common.
Next one is a joint tenancy with right of survivorship. Erin, you want to take this one?
Certainly. The joint tenancy with right of survivorship requires 4 unities: unity of time, title, interest, and possession. Each tenant owns an equal share of the property. Right of survivorship is not available where the percentage differs between the tenants, as it will destroy the unity of interest. So in Frank's prior example, I am not able to hold a 66% interest as a joint tenant. The deed should read Frank Koser and Erin Fagnelli as joint tenants with right of survivorship, and we both own an undivided interest in the whole. Upon the death of one joint tenant, his or her interest automatically passes to the surviving tenant. So in our example, should Frank pass away first, then I am this sole surviving joint tenant, and I would then own the property. If for some reason you attempt to specify a percentage interest or a fractional interest in a joint tenancy, it will be deemed to be you've created a tenancy in common.
Correct. So using the example that Erin had used previously, if we were to do a deed and it said Erin holding a 66% interest and me holding a 33% interest as joint tenants with right of survivorship, the law would presume that to create a tenancy in common because we have placed fractional interests into the deed. Another thing that's important to note is that if, for example, a co-tenant passes away in a joint tenancy, the surviving tenants then end up owning their interest in the property. However, there's still inheritance tax due. What we've seen a few times, at least I've seen a few times over the course of my careers, parties will put property in a joint tenancy with the mistaken belief that by doing that, whenever the first tenant passes away, that title is going to pass to the second tenant, the surviving tenant, without any inheritance tax obligations. And that is not the case. And the ironic thing about that, obviously, is if you own properties of tenancy in common and you pass away, obviously your interest gets passed on to your heirs by virtue of whatever your last will and testament provide for. And of course, your heirs will pay the inheritance tax, but they get the property. In a joint tenancy with right of survivorship, your property interest is going to pass to the surviving tenants, regardless of whether or not they're named in your will. And on top of that, your estate gets the burden of paying the inheritance tax. So, really speaking, a joint tenancy with right of survivorship is something really I only recommend to my clients whenever you have some type of property that the goal is to keep it in the family. You know, perhaps it is the family vacation home and mom and dad leave it to the 3 kids, and they want to make sure that each kid, has an interest in it, but that the last surviving child ends up with the property. That's where a joint tenancy with right of survivorship makes the most sense. I mean, there are other ways around that. You could put it in a trust, but that's really the only time, in my opinion, that a joint tenancy makes sense. Now, a joint tenancy can be severed by any of the tenants as long as they destroy any one of the 4 unities. And some examples of that would be a conveyance to a straw party, a judgment in partition, not a filing of a complaint in partition. Merely commencing a partition action will not terminate a joint tenancy with right of survivorship. An actual judgment in partition will serve as a termination, or an execution by creditors. So, using the example of a straw party, I had a case about 15 years ago where I was representing an elderly gentleman who had purchased the office building with his 26-year-old business partner, and they had a falling out, and he tried to sell the property, and her response to him was that, well, I'm 28, you're 74, chances are I'm going to outlive you, I'm going to end up with it anyway. So the reason we were able to give him some relief then is we brought him into the office. We did a straw conveyance where he conveyed the property to an individual in my office, who then conveyed it back to him. At that point, we severed the joint tenancy and were able to get his interest in the property to him individually. Okay, now if title is held by more than 2 parties as joint tenants, the act of severing the joint tenancy by one of the tenants will not affect the joint tenancy as to the other joint tenants. However, the severing tenant holds his or her interest as a tenant in common. So let's say Aaron and I and 2 of our friends buy a property as joint tenants with right of survivorship, and I sever the joint tenancy. I go through the process of getting a straw party involved, and I sever my interest. That would then mean that I hold a quarter interest as a tenant in common, but the other 3 still hold the 3/4 interest as joint tenants. Go ahead, Aaron. You want to talk about tenants by the entirety?
Certainly. Tenancy by the entireties. Only a married couple may hold as tenants by the entireties. A conveyance to a married couple is presumed to create a tenancy by the entireties unless the deed includes clear and convincing evidence that that was not their intent. For example, if you are going to convey title to a married couple and they do not want to hold as tenancy by the entireties because it's their second marriages and they want to keep their respective interests separate, then you would specifically designate on that deed Aaron and Frank as tenants in common and not as tenants by the entireties.
Correct. And it's important to note that if a married couple purchases property prior to marriage, a new deed must be executed after the marriage in order to create a tenancy by the entireties. Just simply getting married does not in and of itself convert property to a tenancy by the entirety. So in other words, if a couple decides to buy a house when they're engaged and they take title as tenants in common, them getting married does not automatically convert it to entirety's property. They actually need to execute another deed conveying it from themselves as tenants in common to themselves as a married couple. And one of the benefits of a tenancy by the entireties, obviously, is that creditors of one of the individual spouses cannot attach the property. It has to be a debt of both spouses. So in other words, if one spouse has a credit card debt and there's a judgment against them, the marital property, the entirety's property, is not subject to that judgment because the judgment is only against one spouse, not both spouses. Now, obviously, if it's a joint debt of both spouses, the property can be attached in judgment, but it cannot be attached if there's only one spouse against whom the judgment is entered. Similarly, neither spouse can sever a tenancy by the entireties without the consent of the other. They can't mortgage the property without the consent of the other. They can't sell the property without the consent of the other. Now, of course, that remains in effect as long as the marriage remains valid. Now, if a married couple files for divorce, the property remains entirety's property until a divorce decree is actually entered. The mere filing of a divorce complaint does not sever a tenancy by the entireties. You have to go through the process of a divorce proceeding, and once you get a final judgment in divorce, that then severs the tenancy by the entireties, at which point each of the former spouses owns 50% of the property as a tenancy in common.
And it's a very important practice tip upon divorce to follow up and have a new deed executed so that the title to the property is conveyed to one former spouse or the other. We've seen many situations where that step is not taken, and you ultimately end up having property with an outstanding interest in an ex-spouse. Let's say the other spouse gets married, then later dies. We've seen title ending up owned by the new husband and by the old husband, both at the same time, and it just creates a nightmare to clean up.
Which is particularly is a problem if the former spouse passes away, and then you find out that now, of course, you have to go and try to get your children, or well, if there weren't any children, then of course you're dealing with the siblings, or even worst case scenario, the parents of your former spouse, who probably aren't very fond of you in the first place, and you're relying upon them then to go through the process of signing their interest or their late child or siblings' interest in the property over to their ex-spouse. So never something you want to do. So it's, like Aaron said, extremely important. Once you get the divorce decree, immediately go and get the property deeded to whichever spouse was supposed to get the property as part of the divorce settlement.
And don't use a quitclaim deed, and we'll talk more about that later.
Exactly.
The easiest and simplest way to create a tenancy by the entireties, for example, would be a deed to Frank Koester and Aaron Fagnelli, a married couple. That's all that is needed to be said. And that holds true if for same-sex marriages, the title can be held as A and B, a married couple.
That's correct. And, there hasn't been any case law, at least in Pennsylvania, that addresses this issue. But obviously, once same-sex marriage was legalized in the United States, there was a run, or at least we had a run in the office of couples coming in to have their deeds changed because they had taken title as either as tenants in common or as joint tenants with right of survivorship. There hasn't been any case law that addresses the issue of whether or not same-sex marriage was legal in certain states and not in others. At least it wasn't in our state before the Supreme Court's decision. And so the question did arise whether a marriage that was recognized by a different state but not recognized in the state in which the property was located was sufficient to allow the property to be deeded as a tenancy by the entireties. It's never been addressed by the courts, but we've always, at least here in our state, always told our clients in that situation it's just better to do a new deed. That way you confirm that it's entirety's property. Now that we've addressed the tenancies, let's move on to the second thing, the different types of estates and land. There's fee simple estates. You have the fee simple absolute, which is the most common type of estate, which is where the grantor conveys to the grantee all of the grantor's interest in the property. Next one, we have the fee simple determinable, and in this form of ownership, title reverts to the grantor upon the occurrence of a specific event which the deed sets forth as cause for divesting the grantee of title. So essentially the grantor retains a possibility of reverter, which is both alienable and subject to testate or intestate succession. So obviously a fee simple determinable creates a cloud on title. An example of that would be I convey property to Aaron for so long as no establishment selling alcohol is located on the property. If an establishment selling alcohol is located on the property, then title reverts to me. Another example would be a fee simple subject to a condition subsequent, and in that form, title doesn't pass until a particular event occurs. I would convey title to Aaron upon the day that my nephew turns 36. So until my nephew turns 36, Aaron doesn't get title to the property. Or the final one would be subject to a fee simple subject to a condition precedent. And this is also where a particular event has to occur before deed title passes. Now, this day and age, we really only see the fee simple absolute. I mean, dealing with title claims, obviously, we'll see other types of estates, particularly in downtown Pittsburgh, downtown Philadelphia. You'll still see a lot of reverter, properties that are subject to a reverter, but 99.9% of deeds that are drafted today are fee simple absolute title.
Oh, the life estate, our favorite topic.
Go ahead. I know you love it so much, so you go ahead and start.
A life estate is an estate that continues only for the duration of the natural life of one or more persons. It can be based on the life of that person, or it can be based on the life of another person, which is termed a life estate per autre vie, and you may remember that term from law school. The life tenant, oops, touched my mouse there. The life tenant has the right to occupy and use the property for the duration of the life estate. They can sell, transfer, or dispose of their life estate. The life tenant is obligated not to commit waste on the property and to take reasonable steps to preserve the value of that property.
Now, the interesting thing about the life estate, obviously, is whenever you give somebody a life estate, essentially it's a cloud on title, because obviously if you take title subject to a life estate, you have no right of possession until the life estate terminates. Now, typically where we'll see the life estate is grandma wants to convey her house to her granddaughter, but doesn't want to give granddaughter the ability to kick her out. So she puts a life estate provision in the deed that says that grandma reserves the life estate and the right to reside in the property until she passes away. Now, depending on what state you're in, there's typically, there are almost always transfer tax issues that arise with the life estate, because the life estate has a value based upon the age of the life tenant. So you're going to pay realty transfer tax based upon the value of the life in being. So, and the number of the value of the life in being, I should say, is calculated based upon their age, and they use similar tables that insurance companies use, the actuarial tables, to determine the value of your life. And similarly, when the life tenant passes away, there's going to be an inheritance tax obligation if you reside in a state where inheritance tax is applicable, because obviously at that point, the remainderman who has the remainder interest in the property now has full and complete title. So the death of the life tenant is a taxable event.
Many people are under the misperception that by creating a life estate, they're somehow avoiding payment of inheritance tax, or somehow passing their estate to their heirs. But it's just one of the least preferred vehicles of transfer, in our opinion. From a title insurance perspective, a life estate creates clouds on the title. Often we'll see in the chain of title a reservation of a life estate, and we have no ability to determine whether or not that life tenant is now deceased. So it puts the seller in a position of jumping through some additional hoops in order to track down the death of that life tenant, or if the life tenant is still alive, tracking down that person to obtain their signature.
And what typically we see is whenever somebody takes a life estate, typically the home was the only asset they had. And when they pass away, there's no reason for their heirs to open an estate, which makes it very difficult. I mean, obviously, when you get a title file in and you see that it's subject to a life estate that was reserved by somebody in 1972, chances are someone who was in their 60s in 1972 is no longer amongst us. However, that's not going to be sufficient for Aaron to sign off on the title. So then you have to go through the process of confirming that this person is deceased, and depending on when they passed away and which state they passed in. As I recall, Aaron, there's one state out in the Midwest that refuses to produce death certificates.
That's correct. That's Utah, and it took several months for one of our sellers to obtain a death certificate from the state of Utah.
So the lesson there is if you're going to reserve a life estate, don't die in Utah. But
Right.
one issue we did have once when we taught this course previously was someone asked the question of whether or not you could grant a life estate in the life of the family pet. And the question being, of course, Grandpap has his beloved golden retriever, and Grandpap isn't going to live much longer, and he wants to make sure that old Yeller gets to stay in his favorite abode for the rest of his life. Could Grandpap give his grandson or granddaughter or anybody a life estate in the life of old Yeller? And we researched it exhaustively, and there's no appellate court case in any of the 50 states, 49 states who use typical law, and even Louisiana, which uses its own Napoleonic code. None of the appellate courts in any of those states have addressed that issue. So at this point, we would take the position that you could have a life estate in the life of the family pet. So now that we've addressed the estates, let's move on to the common law deed. Now, the common law deed, the form of the common law deed has not really changed a whole lot in the last 240 some odd years. The only thing that's different now is we prepare our deeds on a word processor or computer. We don't prepare them with the feather pens like they did hundreds of. We don't prepare them with feather pens like we did hundreds of years ago. But the parts of the common law deed haven't changed much in 240 years, nor has the general form changed. So, common law form of the deed is divided into three principal parts: the premises portion, the habendum portion, and the conclusion portion. And we will address these different parts and the different subparts as we go through. The premises portion, you have the date, names of the parties to the instrument, the amount of consideration, the granting clause, the property description, exceptions and reservations if applicable, the recital, the encumbrance clause if applicable, and the appurtenance clause. Now, the date of the deed does not control the transfer of title. The date of delivery is operative. So if I date a deed February 1st, 2023, and I do not deliver that deed to Aaron until February 28th, 2023, the date of the deed is February 28th. And the acknowledgments cannot predate the date of the deed. So, we see this sometimes where sellers moving out of town and they want to execute the deeds prior to the closing. They get the deeds acknowledged, but then the closing officer puts the date of the deed, makes the date of the deed subsequent to the date of the acknowledgement. That deed's going to be void and have to be redrawn because obviously the acknowledgements cannot predate the date of the deed.
The workaround that we've found for that is to date the deed as of February 1st, have it notarized February 1st, but include an effective date that you can fill in later, and that would be the date of closing. So, for example, your deed would read, dated as of February 1st, effective as of February blank. Let's say closing is on the 28th, then you insert the 28th at a later time. That way, the date of the deed and the notary acknowledgement date are the same, and that's what creates the problem in Pennsylvania when they are not the same. Names of parties to the instrument. This is very important. You want to use the full and correct name, no nicknames. You want to use the same name as appeared in the prior deed of record. And then you want to address any changes, whether that be as a result of marriage, divorce, or death of a spouse. But let's talk about full and correct names and not using nicknames, because that brings us to my favorite story of our friend Mudgy.
Yes, exactly. Back early on in my career, I was handling a closing where an elderly couple was selling their home, and they came into the office for the closing, and we had prepared the deed. The husband's name was Joseph, and apparently while he was on a battleship in the Pacific during World War II, he apparently was the best boxer on the ship, and he developed the nickname Mudgy, which I don't understand where it came from, and it's not relevant for this, but apparently Joseph went by Mudgy his entire life. His wife only knew him as Mudgy. She may not even have known his real name was Joseph. But Mudgy became upset when he was presented with the deed, and it did not identify him as Mudgy, and it identified him as Joseph, and he refused to sign the deed. So we had about a 15, 20-minute go back and forth between me and Mudgy until I explained to him that he would not get his check unless he signed Joseph. And he at that point signed it and said that that was the first time he had signed anything with the name Joseph in 40 years, which I don't find believable. But anyway, the point there being obviously is that I don't care what your nickname is. I don't care if you, go by your nickname all the time. Whenever you're signing a deed, you need to sign with your actual birth name. And same thing, obviously, if someone buys a property in their maiden name and then they get married, obviously they need to sign both. If they sell the property after they're married, let's say Mary Smith buys a property and then she marries Bob Jones and becomes Mary Jones. When Mary Jones goes to sell the property, she needs to sign the deed both as Mary Smith and as Mary Jones. And the reason we require that is so that someone searching the title can then pick up the fact that Mary Jones was in fact the same Mary that was Mary Smith who took title to the property.
Right, and it's important to include all of those names in the caption of the grantor on the first page of the deed for indexing purposes, because that is where the recorder is going to look for the proper names to index the deed against in the public record index.
Amount of consideration. Now, the total amount of the consideration has to be set forth for calculation of transfer tax obligations. What we tend to see, at least what we used to see, is they would put $1 as the consideration and then hide the actual consideration somewhere further in the deed. I guess the idea being that a snoopy neighbor who went to the courthouse would just see $1 and not bother to read the rest of the instrument. However, nowadays, with everything being online, it's next to impossible to hide a sale price. So when we draft deeds now, we just put the sale price in the first paragraph. That way, the snoopy neighbor who actually takes the time to go to the courthouse gets rewarded by finding out how much their neighbor's house sold for.
And you can still include a nominal consideration if you like, but then you also need to submit and record a realty transfer tax statement of value. You submit that with your deed. It does not always get recorded with the deed, but it's usually the last page, so the snoopy neighbor gets a little lazy and doesn't quite take the time to look at the very last page of the document. Next up is the granting clause. And this is the portion of the deed where you say grant, bargain, sell, and convey. And you must also identify the nature of the interest conveyed.
Next is the property description. Now, this is probably the most important part of the deed. Now, the property has to be described in a sufficiently specific manner to allow a surveyor to locate the property. Whenever possible, references to a recorded plan should be used. If no reference is available, a meets and bounds description will suffice. At least in the residential realm, I always recommend do not use both a meets and bounds description and a reference to a subdivision plan, because that will create an ambiguity. What we tend to see often, this is the area of a deed where most of the errors take place, because what we see so often is a scrivener, rather than actually taking some time to look at the matter, will just take the prior deed in the chain of title and will simply copy out the property description. And obviously, the extreme example I've seen is where, let's say there was a 100-acre farm and Farmer Bob sells the 100-acre farm to a developer. The developer lays out a subdivision plan, gets it recorded, and then starts selling lots. And while the first lot they sell, the scrivener putting the deed together, instead of describing lot 1 in the subdivision plan, they simply copy the meets and bounds description from Farmer Bob's deed, and now the developer has sold the entire property or conveyed the entire property to the buyer of lot 1. And at the same time, whenever you're looking at the prior deed, I always recommend, if there's a survey, make sure that if you're relying on a meets and bounds description, make sure that the survey actually matches the meets and bounds description, because whenever you're copying a prior deed, you're relying on the fact that the previous drafter actually went through and confirmed that the calls are accurate. And in the course of typing a deed, it's very easy when you're reading like this and trying to type out a deed that a 6 easily becomes a 5, an 8 becomes a 9, 2 becomes a 3, and all of a sudden you've completely messed up the property description.
Frank, we have seen that example of when they attempt to convey out the first lot in the newly recorded subdivision plan, they unfortunately convey the entire property. We've seen that all too many times. What we also see is an incorrect way to remedy that error what we'll often see is a deed from the developer to the individual buying lot 1. Developer conveys the entire 100-acre farm, and then they do a corrective deed from the developer to the individual for just lot 1. That's not the right way to correct it. What you first need to do is the individual needs to convey the whole farm back to the developer, and then the developer can convey lot 1 properly to the individual. So it's
Right.
a two-step process.
Right, because obviously once the developer has erroneously conveyed the entire farm to the buyer, the developer no longer owns anything, so they can't just, you can't just simply take it back. You actually have to have it given back to you.
Correct. Do you want to take exceptions and reservations since you're a big fan?
Oh, absolutely. Now, what we tend to see in deeds is the language that says accepting and reserving all in one paragraph. And it's very important to note that exceptions and reservations are two separate things. Now, they need to be specifically identified in the deed, but an exception involves parcels or rights that were previously conveyed by the grantor or someone prior to the grantor in the grantor's chain of title, whereas a reservation is a parcel or a right being retained by the grantor. I think probably the simplest example would be, let's say a farmer has 100 acres and in 1995 he sells 30 acres of it to one party, and now he's going to sell the last 70 acres to another buyer. The deed would then describe the property and then conclude. The deed would then describe the property and accept out the 30 acres which the farmer had previously conveyed in 1999. Or if the farmer had given an easement across the farm for access or for utilities or anything else, that easement will be listed as an exception so that the buyer understands that they're getting title to the property subject to that easement. As opposed to that, a reservation would be, let's say the farmer's retaining his house and he's retaining 2 or 3 acres of the farm, and he needs a driveway access across the lands that he's selling in order to get to his house. And in that case, the deed would reserve to the farmer a right of access across the property sold to obtain access to his property. Or perhaps the farmer needs an access way for utilities or something of that nature, and he's reserving a utility easement. Or maybe he's reserving the gas rights, reserving the oil rights, reserving any other type of rights. Maybe he's reserving the timber rights or something of that nature. All of that would be a reservation because it's a right that is a new right that is now being created and reserved for the grantor, not something that had already previously been conveyed out of the chain of title. So even though we typically see in deeds exceptions and reservations all listed in a standard clause that says accepting and reserving, the following exceptions and reservations are in fact two separate things.
We haven't sufficiently confused you enough already. Most deeds that you will see begin that paragraph with accepting and reserving, they're from and they're out. That way you don't know if it's an exception or a reservation because that's just the typical customary language.
Which is one of the reasons, obviously, that you should always get a title search when you buy a property. It's actually mind-boggling to me the number of times people buy property and don't spend the couple $100 they would need to spend to get a title search. Now, obviously, if you're borrowing money, if you're financing the transaction, the bank's going to require a title search because they need to make sure that the property they're lending money on is secured and that you actually are taking full and complete title. Now, obviously, where we'll see this, the problem is people who are paying cash for property and just decide they want to save a few $100s by not buying the title insurance policy. They're the ones that end up getting burned because obviously without a title search, you're never going to know what exceptions may be out there. Obviously, the seller is obligated to tell you what, if there's easements and whatnot against the property. However, there may be instances where the seller themselves are not aware of an exception that may have occurred 2 or 3 grantors prior in the chain of title. So since Aaron works for the title insurance company, I'll do the plug for title insurance so it's not that obvious. I always recommend if you're doing a cash transaction, it's worth spending the couple $100 in the cost to get the title insurance done. We have a question.
Thank you, Frank, for the shameless plug. And before we answer that question, I'm also going to do a plug of our book. Fagnelli and Koester on Deeds, third edition. Note the black and gold Pittsburgh theme here. This book is only available through pbi.org. It includes a wealth of information that we're not going to have enough time to present today, and it also includes 18 different forms of deeds. And Frank and I always say at every seminar, if you have a question, feel free to reach out to either one of us. We're happy to help you with a deed drafting question or anything else involving preparation of a deed. So we do have a question here. I'll go ahead and read it for the audience. How would a corrective deed switching out the Exhibit A not fix the developer conveying the whole farm issue? I think we've already answered that, but if the developer conveys the entire farm to Frank and then executes a corrective deed conveying only lot 1 to Frank, the developer does not have title to lot 1 any longer. He first needs a deed from Frank back to the developer for the whole farm, and then the developer can convey lot 1 to Frank.
Using the example that I actually used with my 6-year-old this morning, let's say that Daddy only intends to give his little girl 3 Oreos, but then Daddy inadvertently gives her the entire box of Oreos. Now, before I can give her just the 3 Oreos, I have to take the entire box of Oreos back and then hand her the 3 Oreos, presuming she hasn't eaten them already. But the idea being, obviously, once I give her the entire box, I can't just I can't just give her 3 now because I've already given her the entire box. I have to get the box back from her before I can give her the 3 Oreos. So
that's a great example.
Thank you.
Hope that answered the question. If there's more questions, feel free to ask. We love to have interaction during our presentations.
All right, Aaron,
Next,
I know you love the recital, so go ahead.
It warms my heart, Frank.
I know.
The recital is one of my favorite parts of the deed. It's also the most important. This is the opportunity to tell the story of the chain of title, and nothing is worse than when a title searcher comes upon a deed in the chain of title that has no recital, because then it doesn't give them any direction or any path to follow. So typically your recital will recite the prior vesting deed, and then it will also give you the opportunity to add any additional facts that are off-record facts, meaning a deed from Mary Jones, formerly known as Mary Smith, in your caption of your deed. In the recital is where you want to explain Mary Jones, or Mary Smith took title, and she's now married, and her married name is Mary Jones, and it gives an explanation to the reader as to why there's a change from the current vesting deed to the current grantor's name. This is also the area where you want to recite the death of one of the persons in title. You want to recite their estate information. If your grantor is a corporate entity and it's changed its name, you want to recite the name change or merger or whatever is applicable that tells the story of how you got from entity A to entity B.
All right, and it's important to note, I've noticed the further on I get in my career, when I use this example, it seems less people know who I'm talking about. But the example I like to use is Zsa Zsa Gabor, who was married, I think, 12 times. If Zsa Zsa Gabor took title to property when she was married to her first husband, and she sold it when she was married to her 12th husband, you would want in the recital to list, being the same property conveyed to Zsa Zsa Gabor. Zsa Zsa Gabor then married so-and-so, married so-and-so, married so-and-so. You would want to list in the recital all of the different last names that she had, because that is the only way a title searcher can go in and search and confirm that there aren't any intervening liens that may have been filed against her when she had a different last name. So, I know that's using the extreme example, but any name that the grantor went by during the time that he or she owned the property, that needs to be included in the recital so that there's a detailed explanation as to the name changes. And also, of course, one of the favorite ones we had was once, as I recall, we had a situation where a husband was selling property out of a divorce, and he wanted the recital to include all of the various men that his ex-wife had relationships with, which he thought was relevant to include in the recital. However, we advised them that that was not necessary, nor would it be appropriate. The recital needs to just tell the story of title. We don't need to get into personal family history.
We have a follow-up question before we move on. The question is, so the corrective deed does not supersede and replace the Exhibit A. That is correct. In our extreme example of conveying the entire farm versus only one lot, a corrective deed does not supersede and replace that legal description. The only time a corrective deed would supersede and replace the legal description is when it's a much more minor of an error. Let's say one of the calls was different east to west, or one of the numbers was off in a degree. Something, an error of that nature can be corrected simply by one corrective deed, but not in our extreme example.
And believe it or not, even though it is an extreme example, we've seen it happen more than once.
Oh my gosh, it's ridiculous how many times we've seen it.
Next is the Encumbrance Clause, and in the Encumbrance Clause, we would identify any encumbrances which are passing with the title. You know, in older deeds, when parties used to assume mortgages, obviously the Encumbrance Clause would identify the mortgage and its recording information. Obviously nowadays, mortgages are almost never assumed. They're paid off at closing, so we don't see mortgages being referenced very often in Encumbrance Clauses. What we will see, though, is easements, restrictive covenants, things of that nature. So if the property is subject to a homeowner's HOA declaration, you want to reference the HOA declaration here. If there's any other sort of restrictive covenant, perhaps, you know, building restrictions, the size limitation or minimum house size, things of that nature. If there's a power line going through your backyard, obviously that will want to be listed under the Encumbrance Clause. Of course, though, a failure to reference it will not protect the grantee from the encumbrance. So obviously, if I buy a house and when I'm looking at the house, I see that there's a driveway going through the side yard to the neighbor's property behind me, and the deed does not address this driveway easement, the mere fact that it's not included in the deed doesn't mean that I took title free and clear of that easement, because by inspecting the property, I know that the easement is there. And obviously, if the grantor fails to include that language in the deed, they could potentially be subject to liability. We're not going to see that, obviously, in the driveway issue, because obviously that can be readily seen from an inspection of the property. However, I have had cases over the years where the grantor is given an easement for a water line or a sewer line or something like that on the property, and they failed to include it in the deed, and they've been subject to liability then, because the easement either wasn't recorded or it wasn't properly indexed, so the title search didn't pick it up. But the buyer, so the buyer wasn't aware of it, but the seller failed to reference it in the deed. So for that reason, the seller was liable for damages. So any encumbrances you're aware of, important to put them in the deed.
We'll often see this as an exhibit after the legal description, usually named Exhibit B, and they'll call it permitted encumbrances, and then they'll list all of the recorded encumbrances against the property. We do have another question. Thank you for the questions here. What names need to be listed for the signature line for a married woman who has changed her name at least one time? Does she need to sign twice, one per name change?
Yes, I always require it.
I would agree. I think it's also important to include both names in the caption of the deed, both names in the signature line, and both names in the notary acknowledgement. You want all three of those areas to include the same names. Otherwise, you risk rejection by one of the recording offices.
Next is the Appurtenance Clause, and this is where we identify any structures on the property by their description and address. Now, typically we don't put property addresses in deeds anymore because addresses will change. We'll put the tax parcel number, but we won't use the address. And oftentimes, I mean, some deeds I still see people will insist on putting in the deed the type of house. If it's a colonial, you know, two-story colonial or one-story frame house, people still want that put in the deed for whatever reason. It's not necessary to convey title. I've always taken the position that, you know, unless you're getting something very unique, there's no particular reason to describe the structure on the property, because obviously someday, you know, you may tear the house down and build a different house. And, you know, you're not creating an ambiguity, obviously, when you sell the property, but at the same time, then someone searching the title may question what happened to the house. So, unless there's some real reason to describe the property you're getting, typically we don't describe the structures on the property anymore.
There are some counties that do require an address to be included on the deed. Washington County in particular now requires the acreage to be included in order to get the deed recorded. I understand there's been some arguments with Washington County to get that acreage requirement removed, but as far as I'm aware, it has not yet been removed as a recording requirement.
Well, unfortunately, that's still the case. And it doesn't matter what state you're in. It seems that every county has their own rules and procedures that they want followed. So we always recommend, go to the county recorder's office if you can before, take a draft of the deed to them and make sure that they're going to accept it for recording before you get it executed. Because the worst thing that can happen is you go through the closing, you get the deed signed, the money's changed hands, and then the recorder rejects your deed on some sort of technicality. Now you have to go back and get the seller, who has no need to cooperate with you now because they've already gotten the money, and you need to get their signature on a new deed. So it's always better to spend the time beforehand and go to your county recorder's office with the draft and make sure that they'll accept it before you actually get it signed by all the parties.
And that's particularly important in Allegheny County now that there's a pre-certification process. So anytime your legal description is changing or your parties are changing, we will take our deeds in Allegheny County up for pre-certification to avoid that exact problem at closing.
And you just have to hope that the person you go to that day is the same person you take the deed to when you record it. I've had that happen a few times where I've gotten it certified and I take it back and the person says they shouldn't have certified it. So that's
it has a stamp on the front page now, so you'll get it on record.
Okay, next is the Habendum portion of the deed, where we have the to have and hold clause, the covenants of title, warranties, and the general covenants. The to have and to hold clause is ambiguous. We don't use it anymore. So we see it in ancient deeds, but we don't put it in new deeds now. Okay, now the covenants of title, we have the covenant of quiet enjoyment, the covenant against encumbrances, the covenant of season, the covenant of further assurances. And we'll go through these quickly because I see we are quickly coming up on 10 minutes left in the seminar. So let's talk quickly about the warranties of title.
Sure, the warranty.
Go ahead, Aaron.
Warranties of title, we have the general warranty deed, which is where the grantor is warranting to the grantee from the beginning of time. You don't typically see too many general warranty deeds anymore, especially in the eastern part of Pennsylvania. Special warranty deed is much more popular because it's limiting the liability of the grantor. The warranty provision is only for so long as the grantor has actually held title. And as a practice tip, if your buyer wants a general warranty deed, you may want to build a little extra consideration into your transaction in order to make it worth the grantor's while to warrant title for a longer period of time.
Well, exactly. So keep in mind, if you give somebody a general warranty, you're warranting title to the property back to the beginning of time, not just during the time that you've owned the property. Whereas if you give them a special warranty, you're only warranting against encumbrances that may have, that occurred during the time you own the property. So if you're giving somebody a general warranty, make sure you're getting extra money for it. Next, we're going to deal with covenants, general covenants. A real covenant is a covenant that runs with the land. A personal covenant is a covenant that's exclusively between the grantor and the grantee. So a real covenant would be, let's say, you convey the property and you say that no house smaller than 3,500 square feet can be built on the property. As long as the covenant in the deed says that this covenant shall run with the land, that is a real covenant, and it will bind all successors in interest down through the chain of title unless they can get the grantor or their heirs subsequently to waive that covenant. Now, if you say, subject to the covenant, that no house smaller than 3,500 square feet can be built on the property, and you don't say that this covenant shall run with the land, it then becomes a personal covenant, which means it is exclusively between the grantor and the grantee, and it only applies for as long as the grantee owns the property. So the grantee cannot build a house smaller than 3,500 square feet on the lot, but as soon as they convey the lot to somebody else, they are free and clear of that covenant because it was a personal covenant not a real covenant. So the magic language there is runs with the land. If you want it to bind all successors and interest, you need to include runs with the land. If you don't, it's a personal covenant and it disappears as soon as the grantee's title disappears. Finally, we move on to the conclusion section of the deed, where we have the execution clause, the receipt, the acknowledgement, and the certificate of residence. Now, the execution clause, obviously, the party needs to sign same name as it appears at the top of the instrument. So obviously, if you're in most states, a deed only needs to be executed by the grantor, and a deed does not need to be witnessed, but the grantor has to sign it in the same way as they're identified on the first page of the deed. So again, if the deed, first page says Robert M. Smith, you need to sign Robert M. Smith. You need to, you can't sign Bob Smith or Rob Smith or anything of that nature.
And while a deed does not need to be witnessed, it's very good practice to have it witnessed in order to protect against claims of fraud or forgery, and your notary can be the witness as well.
Okay. Aaron, you want to take corporations?
Certainly. Only a corporate officer can execute a deed. Also, it's necessary for the corporation secretary to attest that the seal has been properly affixed. Now, we don't actually see a corporate seal on documents anymore, but typically there's a statement in the deed that says that the grantor has signed under seal. So for an individual, you want to have a witness. For a corporation, you want to have an attestation.
Now, receipts, we don't really see receipts anymore. They're not required. They used to be used to prove that the grantee has paid the purchase price, but nowadays they're pretty antiquated. We generally don't see receipts in deeds anymore. Now, an acknowledgement, go ahead, Aaron.
A recorder of deeds will not accept a deed for recording where the acknowledgement predates the date of the deed. We've spoken about that earlier. You need an acknowledgement for every signatory on the deed. So if your deed is being signed by 3 individuals, you need an acknowledgement for all 3 individuals. You can put them all in one acknowledgement, or you can have a separate acknowledgement for each individual. Either way, you have to make sure that everyone that signs has an acknowledgement. It may seem silly that I'm even saying that, but I've received many, many deeds for review and approval, and we're missing acknowledgements for half the parties.
Now, the certificate of residence, obviously that's needed for, number one, the recorder's office needs to know where to send the deed once it has been indexed and scanned into the system. And obviously the tax office wants to know where to send the real estate tax bills. So that's why it's important to have a certificate of residence on the deed. Most recorders won't accept a deed if there's not a certificate of residence included on the last page.
Allegheny County has a particular form required for certificate of residence, and that's available on the Allegheny County website.
Now, let's briefly talk about other types of deeds that we have not addressed. Number one is a fiduciary deed, and we tend to see this where the grantor is acting as an executor, guardian, trustee, or administrator of an estate. And obviously, there's 2 very important differences in a fiduciary deed as opposed to a regular deed. Number one is the statement of the source of the grantor's authority. And in that case, obviously, you have to include in the deed language that references how the grantor got the authority to be the executor, guardian, trustee, or administrator. You want to include language. If it's an estate, obviously, you're going to include language that identifies the decedent, the date of death, where their estate was probated, as well as the date that letters were granted and the person was named executor. Similarly, if it's a guardian, someone's incapacitated and they have a guardian appointed for them and the guardian is now selling the real estate, there's going to need to be reference to the guardianship proceeding, the case number, and the date that the court order was issued appointing that individual as the guardian. Same thing if it's a trustee, you need to reference the trust document that created the trust and name the individual the trustee. And similarly, the warranties that are granted are going to be different because obviously if you're the executor or you're a trustee, you are not in fact conveying the title on your own behalf. You are conveying the title on behalf of the ward or the incapacitated person or the decedent, the estate. So therefore, the only warranty you're giving is that during the period of time that you served as guardian, trustee, executor, or administrator, that you did not undertake any actions to encumber the title. That's the only warranty you're giving. You're not warranting good title for the entire duration of the time that the decedent or the incapacitated person owned the property. You're only warranting that during the time you were the trustee or the administrator, executor, whatever, that you didn't undertake any actions to encumber the title.
Another form of deed is the quitclaim deed, which is often misused. A quitclaim deed only conveys whatever interest the grantor may have in the property, if they have any interest at all. A quitclaim deed conveys no warranties of title, and it's the least desirable form of deed. It should be used for curative measures. For example, if there's an outstanding interest of an individual back in the chain of title, a quitclaim deed would be the proper form of deed to use for that individual to convey their interest now to clean up the title. It should not be used for family transfers. It should not be used for estates.
And what we often see with quitclaim deeds is the way they're misused is people take the position that, oh, you know what, I never had any, grandma died, and I was one of grandma's 12 grandchildren, and my one of my cousins is taking grandma's house, and since I have no interest in the property, I'm just quitclaiming you my interest in the property. And that's not the correct way to do it. The correct way to do it would be for me to actually convey my interest in the property to you, because a quitclaim deed's not, any one of us can give anybody else a quitclaim deed to the Empire State Building, to any other landmark in the United States. It doesn't mean that we actually are conveying anything. It just means that all I'm saying is that to the extent I have any interest, I'm giving it to you. I'm not actually warranting that I have any interest to convey to you. All I'm saying is that to the extent I own anything, I'm giving it to you. Now, deed delivery. Delivery is necessary to render a deed legally operative. Absent delivery, a conveyance is void. Delivery does not necessarily require placing the deed into the hands of the grantee, rather the intention of the grantor controls. So, in other words, if I sign a deed and I convey a property to Aaron and I put it in a shoebox, does that constitute delivery? What do you think? Does it constitute delivery?
No, it does not.
Also, conditional delivery or delivery in escrow of a deed is not delivery to the grantee, and unless the conveyance would have some detrimental impact on the grantee, acceptance of the delivery of the deed is generally presumed. So, of course, in states where it is not necessary for the grantee to sign the deed, using the extreme example, if I own a toxic waste dump and I want to give it to somebody I don't like, I can execute a deed and record it, and now I've given them the toxic waste dump. Of course, their protection is that the law will take the position that if the conveyance is detrimental to the grantee, the acceptance of the deed will not be presumed, and obviously that's the grantee's protection. Now, deed recording. Deed must be recorded in order to establish priority against lien holders, judgment creditors, and bona fide purchasers without actual or constructive notice of the transaction. And at the time of the recording, all requisite state and local realty transfer taxes must be paid unless the transaction is exempt. And if the deed is executed by a third party on the grantor's behalf pursuant to a power of attorney, the power of attorney must be recorded with the deed. Now, obviously, a lot of counties have power of attorney books where powers of attorney can still be recorded, although we don't see that very often anymore. Typically now what we'll see is if someone gives a family member or whoever a power of attorney and they sell the property, the power of attorney will just be attached to the back of the deed and they'll be recorded as a single document. I see we have another question here. What type of deed is best for a grantor to use when funding their own living trust? Special warranty deed?
I would say so, yes. You want to use a special warranty deed. You do not want to use a quitclaim deed.
Okay, setting aside a deed. A deed will only be set aside under limited circumstances, and the party must prove that the transfer was the result of one of the following: undue influence, fraud, lack of mental capacity, or the existence of a confidential relationship. And obviously, depending on which state you're in, case law is going to control on that, but it is very difficult to set aside a deed. And reforming a deed. Go ahead, Aaron.
Sure. A deed will only be reformed if there was a mistake in its execution. The mistake must be mutual. Reformation may also occur where there's a unilateral mistake and the other party is aware of the mistake.
So the example there being obviously if I own 100 acres and I meant to give you 10 and I accidentally give the 100 and now you don't want to convey the 90 acres back to me, you know, we can go back to the agreement of sale and see that the agreement of sale provided for 10 acres and it was a mutual mistake and therefore I'm entitled to get the 90 acres back. And finally, deed construction, absent proof of fraud or mutual mistake, the nature and quality of the interest conveyed is to be ascertained from the language of the deed alone, and a deed must be construed so as to comply with the party's intent. If the language of a deed is vague or ambiguous, extrinsic evidence may be applied to clarify. So it's very similar to a standard black letter contract law. If there's ambiguity, that's the only time we go outside the four corners of the document. Well, we've made it to 3 o'clock. If we have any further questions, we'll be glad to answer them.
We do have a question here. Can I deed joint tenants, not married, mother and daughter, into each of their own living trust?
I don't see why you couldn't. I guess the question would be if you have two separate living trusts and you wanted to convey a half interest into each trust, the first thing you'd have to do is you'd have to sever the joint tenancy. I guess the easiest thing there would be to convey the property from mom and daughter as joint tenants to mom and daughter as tenants in common, and then they could each convey their half interest into their living trusts.
Agreed.
So it's a two-step process.